Hey, welcome everybody. Welcome to the Law of Self-Defense live stream for January 12th, 2020, our live Q&A session once again. Thank you all for joining us today. It is much appreciated as always. My goal today is to knock out the remaining 200 questions left over from our live Q&A from this past Saturday. January 8th, 2022, when we did our Law of Self-Defense Advanced class, our full-day class on use of force law, the one we only teach every year or two. I think the last time we taught the class was about 18 months prior. It's our full-day course, the equivalent of a law school education on use of force law, if law schools had a semester-long seminar on use of force law, which, to my knowledge, none of them do, which is unfortunate. And during the course of that 8.5 hours of continuous talking by yours truly for that advanced class, we received a lot of questions, roughly 500 questions over the course of that 8.5 hours. We answered a ton of them that day, Saturday, about 150 of them, but that clearly left a lot to cover. So this past Monday and Tuesday, we knocked out another 150, 100 questions a day. That leaves us with about 200 remaining. Hopefully, a lot of the 200 are duplicative of what I've already answered the previous days. So we hopefully don't have to cover 200 today. But I'd like to finish our list of questions. And of course, if you submit questions during this live stream show using the super chat function, that's the only way I can pick out selected questions to answer, folks. I'll strive to answer them during the course of the show today. So that support is always appreciated. For those who don't know, I am attorney Andrew Branca for Law of Self-Defense. Law of Self-Defense is a small law firm based out of Colorado. Our focus is exclusively on use of force law. So defense of self, defense of others, defense of property. We don't have a generalized criminal defense practice. We only do use of force cases. And our legal practice is largely consulting on other attorneys' cases. So we're not the lead counsel on a self-defense case, use of force case. Our client is not the person charged. That person charged has retained their own lead counsel in whatever their local jurisdiction is, and our client is their attorney. So we provide consulting services to their attorney. Effective this year, we only provide consult services to people who are platinum members of Law of Self-Defense. We have 2 levels of membership here. One is our standard membership, by the way, which you can try for 2 weeks for just 99 cents, folks. 99 cents for a 2-week trial of our standard membership gets access to our many thousands of blog posts, thousands of hours of video and podcast content that's restricted to our members. You can try it out for 2 weeks for 99 cents. If you decide to stay a member, and virtually everybody does decide to stay a member, it's still cheap, folks. It's only about $0.25 a day for standard membership, less than $10 a month to be a member of Law of Self-Defense. And then above and beyond that, we have what we call our platinum level membership, which is includes everything from the standard membership. And by the way, that trial, 2-week trial for the standard membership for 99 cents, you can access that at lawofselfdefense.com/trial. It's only 99 cents, folks. In fact, if you don't like it in that 2-week period, we'll refund twice your money. It's only twice 99 cents, but let's face it, we didn't ask for much up front in the first place. So lawofselfdefense.com/trial, or as Emily, who's moderating today, my lovely wife, Emily, you can go to lawofselfdefense.com/join and simply sign up as a member. So there's standard membership, and then there's platinum membership, which gets all the benefits of standard membership. Plus, you get our legal consult service for free should you be involved in a use of force event. Normally, our legal consults start at $10,000 as a flat retainer, folks. That's the minimum. But effective January 1st of this year, we're not taking consults from non-platinum members. You have to be a platinum member to receive a consult for us. And when you do, you don't pay for it. There is no $10,000 retainer for you as a platinum member. It's simply included as part of your platinum membership. For those who are asking, by the way, it's we don't talk about it much, but it's not a secret. My wife Emily recently had surgery for breast cancer. She's recovering beautifully. The doctors tell us they got everything, so we shouldn't have any cancer concerns moving forward. It's about as positive an outcome as we could possibly hope for. Of course, the recovery from the surgery is a long process, which Emily's handling like a champion. But the serious risk ought to be behind us. That's what the doctors are telling us. So, for those of you who were sending prayers and wishes, thank you very much. I guess they worked, and everything on our end is going as well as we could, again, possibly have hoped for. And I guess I should tell everyone to please, you're watching this on YouTube, please subscribe, click the like button, all that other stuff. Sorry, folks, I'm not that social media savvy, but presumably all of you are. So please do whatever it is that you're supposed to do to help us grow the law of self-defense community. That's always greatly appreciated. One other thing I should say about membership, by the way, so we do most of our content is members only content. When we do publicly accessible content like this live stream on YouTube, we also typically add components to it that are members only, like a podcast component, or we do provide our members with a computer generated transcript of these live stream videos. That transcript's only available to our members. A lot of people like to be able to kind of quickly read through, scan a written form of this content, which only takes a few minutes to do. And then they can, if they see things that are of particular interest, there's timestamps throughout the transcript, and they can just zoom to that part of the video and read it. It's a more efficient use of time than watching, these live streams are often 2 hours at a time of content. It's quite a time commitment to try to filter through all of it in real time. Of course, in the podcast mode, you, like most of us, I assume, you would listen to it at 1.25 speed or whatever your preference is, or you get in the written transcript if you're a member of Law of Self-Defense. And again, you can learn more about that at lawofselfdefense.com/join. Also, I had a few questions about this Edgecombe trial about to start up next week. This is where the defendant, who happens to be black, shot and killed a white immigration attorney after some kind of confrontation between the two of them. I've been asked if I'll be covering that case. I will be writing about it this week for sure, again, for our members. And then if the trial is broadcast live, and I believe from what Court TV is suggesting that it will be broadcast live, then we may well, depending on what the case looks like after I write about it this week, after I dig a bit deeper into it, but it's likely we'll follow that case in real time, like we did the Rittenhouse case and the Potter case and the Ahmaud Arbery case, and so forth, because it is the defense is claiming the shooting of the lawyer was self-defense. Superficially, so far, I have serious questions about that self-defense claim, and most claims of self-defense are BS. So that could well be the case here as well, but we'll learn more as we dig more into the case. But for those asking about it, I am looking closely at the case. Right now, I'm leaning towards the expectation that we'll be covering it live starting next week. Next Tuesday, jury selection begins in that case out of Wisconsin. This is Wisconsin v. Edgecombe. Let's see what we have here so far. Okay, so I think I have touched on everything I wanted to in an introductory manner. We've got a bunch of people now rolling in, so that is good news. And we'll jump right now into the leftover questions from our Law of Self-Defense Advanced class from last Saturday. Now, when I come across questions that I know I recall answering in the previous 2 days, Monday and Tuesday, stuff like the Castle Doctrine, which I touched on a ton yesterday, the limits of the Castle Doctrine, stuff like defending against animals. We spent quite a bit of time talking about that. I'm just going to skip over those questions today. You can get my answers on those issues in the previous day's content. Also, if you happen to attend the advanced class on Saturday and you'd like to say nice things about it in the comments, that's always appreciated as well as a kind of social affirmation of the quality of that content, which we appreciate. Okay, let's see here. Someone's asking about reasonable perception in the context. It looks like in the context of defense of others. So generally speaking, you're privileged to use force in defense of other people to the same extent they would be privileged to use force. in defense of themselves, or alternatively, to the same extent, you would be privileged to use force in self-defense if you were in their position. So that's a general framework for defense of others. It's largely parallel with self-defense. It's the same 5 elements, or up to 5 elements of self-defense. Those elements, of course, are innocence, imminence, proportionality, avoidance, and reasonableness. By the way, if you're not familiar with those 5 elements, you really can't understand use of force law unless you understand those 5 elements. If you'd like, we have an infographic on them. It's an absolutely free PDF download. Lists those 5 elements, provides a brief explanation of each. You can get that PDF download for free. It doesn't cost a penny, folks, at lawofselfdefense.com/elements. There's also, for those of you who may be instructors and have a classroom, there's a poster size option of that infographic. We do charge for the poster. Obviously, we have to print it and mail it, but the PDF itself is free to download. Those 5 elements are innocence, imminence, proportionality, avoidance, and reasonableness. And they're cumulative. All the required elements are obviously required. Self-defense is extremely binary. Either you qualify or you don't. Either you have the legal defense and 0 legal liability, or you don't have the legal defense because you're missing one of the required elements and you have 100% legal liability. So very much like a light switch, either on or off. And the elements are really the same for defense of others and self-defense. In fact, many states, their use of force statute combines defense of self and defense of others. It would literally say you're privileged to use force in defense of yourself or another person if the elements are checked off. And it goes on to list the elements, of course. Other states have separate defense of self and defense of other statutes. There'll be separate statutes, separate statute numbers, but the underlying elements are the same. Now, historically, there was a wrinkle in defense of others in many states. So some states would hold that when you were defending another person, there's always a risk when you come to the defense of a stranger in particular, that you're getting yourself involved in a fight and you don't really know what's going on, right? You turn a corner, you see 2 guys fighting, you decide to come to one person's defense because it appears they're on the losing end of that fight. But for all you know, they started that fight, right? For all you know, they were actually the initial aggressor, and the person they attacked is simply gotten the upper hand in defending themselves. So when you come to the defense of the person that looks to you like the victim in that case, they may have been actually the initial aggressor. You don't know. So historically, about half the states would apply to that situation what they call a reasonable perception standard. And this is much like the reasonable mistake standard for the element of reasonableness in self-defense. The idea is that we're not required to make perfect decisions in self-defense. We're required to make reasonable decisions in self-defense. And if you make a mistake, if you have a misperception, but that mistake is reasonable, then your claim of self-defense is still valid. It's as if someone pointed a gun at you, demanded your wallet, you stepped off the X, drew your own gun, shot them dead, and then it turned out their gun was not a real gun. It was a realistic looking toy. So you shot them because you thought they were presenting a deadly force threat to you. In fact, they were not. That toy gun could never have inflicted death or serious bodily harm upon you. So technically speaking, you made a mistake, but it was a reasonable mistake. If a reasonable person would have perceived that toy gun as real, that's all that's required, a reasonable perception of the threat. The threat need not be actual. It need be reasonably perceived. So historically, about half the states would apply that same paradigm of reasonable perception to defense of others. So if you turn the corner, you see 2 people fighting, you come to the defense of one of them, and later it turns out that guy was the initial aggressor in the fight. As long as your perception of them as the victim was a reasonable perception, you're good to go. You made a mistake. They were actually the initial aggressor. They would not have had a privilege to claim self-defense for themselves because they would have had lost innocence because they were the initial aggressor, and innocence is a required element of self-defense. But you had a reasonable perception of them as the victim. Therefore, your use of force in defense of them remains lawful. But about half the states historically had a slightly different standard, and that was called the alter ego standard. And under the alter ego standard, your right to use force on behalf of that other person extends only as far as their own actual right to use force in self-defense. So let's imagine a scenario where you turn a corner and you see two guys, you see a man struggling with a woman. He's grabbing her, he's holding her, and she's screaming for help, that she's being kidnapped, that she's a rape victim here. Kidnapping and rape are deadly force threats. She would be privileged to use deadly force to defend herself against rape or kidnapping. So, in theory, you're privileged to use deadly force on her behalf. But when you go to do that, it turns out after the fact that she's not being kidnapped or raped. She's being subject to a lawful arrest by an undercover drug agent who didn't look to you like a cop. Your reasonable perception was that this woman was telling the truth. There was no badge, there was no uniform, there was a kind of a scruffy looking dude grabbing at her. So you had a reasonable perception that this was a kidnapping or a rape, but that perception was mistaken. In fact, it was a lawful arrest. Well, under the alter ego standard, your right to use force on her behalf extends only as far as her own right to use force. And her right to use force to resist a lawful arrest is zero, which would mean under the alter ego standard, your right to use force on her behalf is zero. Now, the good news is really nobody applies the alter ego standard anymore. Over the decades, it's been abandoned essentially in favor of the reasonable perception standard. Now, there is one state, and it's the question here says North Carolina. I'm not sure what they're getting at there, but South Carolina. If you look at South Carolina law, this alter ego standard tends not to be, well, sometimes it's in statute, but often you have to look to court decisions, appellate court decisions that are applying these statutes to real people in real cases. So they get to a lot of these subtleties. And if you look at South Carolina case law, the most current case law on this issue does appear to argue the alter ego standard and apply the alter ego standard, which would put it at variance with the other 49 states, which just don't do that anymore. The other 49 states all apply the reasonable perception standard. But here's the thing. All that case law in South Carolina is very old. It's like over 100 years old. And so the appellate courts just haven't really dealt with this issue anytime in several generations. I expect if they had a defense of others case get up to the appellate court level and it dealt with this alter ego issue, that the appellate courts would look at what the rest of the country has moved to and say, no, we're not doing this alter ego thing anymore. That's old law. The modern standard is reasonable perception. That's what will apply. That would be my expectation. But technically, alter ego is still on the books, and a prosecutor could well use that existing case law to argue at trial that the legal standard ought to be alter ego. And you might be subject to that alter ego standard in South Carolina. I would think you would win on appeal, but appeals are for losers, as I often say, and it's certainly no guarantee that you would win on appeal or even that the appellate courts would want to take up the issue. So at least in South Carolina, you should be prepared for the possibility that you might be held to the alter ego standard, which makes coming to the defense of a stranger in a circumstance where you don't know absolutely everything about what happened, and you never really do, it makes that extremely dangerous. Because you don't know if that other person really had a privilege of self-defense themselves, and therefore you don't know if you yourself really have a privilege to use force on their behalf under that alter ego standard. And by the way, folks, it's also theoretically possible, although this should not happen, but it's possible in the other 49 states where the standard is supposed to be reasonable perception, that the prosecution might misstate the law, might tell the jury that the standard is supposed to be alter ego. And the judge may not clarify that, may not correct the jury's misperception. We see this happen. We saw this happen in the Ahmaud Arbery case, where the trial judge allowed for an ambiguous statutory reading of citizen's arrest when citizen's arrest was really the key to the entire trial. We saw this happen in the Kim Potter case, where the prosecution explicitly misinformed the jury about what is required for a guilty verdict on reckless manslaughter. And then Potter was found guilty of reckless manslaughter, presumably under that mistaken view of the law. And the judge never corrected, Judge Chu never corrected that misstatement of law. It was the rebuttal by the prosecution. So the defense side of the argument was done. They had no more opportunity to speak to the jury to clear up this clarification. So it's possible, even in another state, that you might find yourself improperly subject to the alter ego standard if you come to the defense of another person. So again, I don't tell people what to do. I only try to help people make informed decisions about what to do. But this is one of the risks of coming to the defense of others, especially when that other is a stranger and you don't know everything that preceded your involvement in that case. And that obviously discourages people coming to the defense of others. And I think we'll see more people more hesitant to do that moving forward, which I would suggest is not a good thing socially, but given the hazards, that's what I expect to see. Let's see. Scott asks, I have rubber plastic rounds for pistol and shotgun. Would they always be viewed as deadly force? They're called less lethal for terms of liability. So this sounds, Scott, like rounds that would actually be fired from the gun, not just like dummy rounds, inert dummy rounds for dry fire practice, but something would come out of the barrel, presumably some rubber or plastic bullet instead of a lead or jacketed bullet. I would strongly discourage that for a variety of reasons. One is there's always a risk of ammo confusion. You might think you have rubber rounds in the gun, but you actually have real rounds in the gun. And then when you think you're firing a rubber bullet at somebody, you're actually firing a real bullet into them, maybe with fatal effect. And that's essentially the definition of reckless manslaughter. If they die as a result, you knew you were creating a risk that it could be a real round in there, and you ignored the risk. That's reckless manslaughter. And you killed someone you did not intend to kill. You intended to fire something rubber or plastic at them. That's a position I would never want to be in. So my preference is that guns and gun-like things be used as guns, as deadly force instruments only. So they're only used when the conditions for the use of deadly defensive force are warranted. When the conditions for deadly defensive force are not warranted, then I would use an explicitly non-deadly means of self-defense that does not look anything like a gun. By the way, when you have this gun, and even if we pretend that it's harmless, we pretend that you've never owned a real bullet in your life, the only thing that can be in this thing are those plastic bullets, or it's some kind of weapon that can't fire real bullets. It only fires OC pepper balls or something like that. So there's no possibility you could ever inflict death or serious bodily injury on someone with it. That's let's assume for purposes of discussion that's absolutely the case. When you point that thing that looks like a gun at another person, well, that person, like we just talked about, is entitled to rely on their reasonable perceptions of that threat. If they perceive it as a gun, they're allowed to respond to it as a gun. By the way, so is everyone else around. So if the conditions for deadly defensive force don't exist and you're pointing a gun at someone, that would be an unlawful use of deadly force by you. And how do you know somebody standing behind you isn't prepared to use their actual concealed carry gun in defense of that person you're pointing your plastic bullet gun at and shoot you with real bullets? So again, I strongly disfavor using anything that looks like a gun or is a gun with plastic bullets in it for purposes other than actual deadly force self-defense. Keep those categories distinct. I mean, I've actually been approached by companies, entrepreneurs who develop these weird kind of bullets, plastic bullets, wax bullets, with the notion that you could put these in your gun, or maybe the first couple of rounds are these plastic things. So the first couple of times you shoot that person, it just hurts, and you're trying to encourage them to stop doing what they're doing. But if they continue, the next couple of rounds, the next rounds in the magazine would be real rounds. Folks, just don't do any of that. The risk of things going sideways is so obvious and so real that if they do go sideways, your legal liability is absolutely enormous. Let's see. Andrew, great class. Thank you, Russell. That's from Russell. Since you've been carrying for so many years and a lawyer also, what's the most common legal entanglements those who carry have? Well, I've carried a gun every day of my adult life. Even the 25 years I lived in Massachusetts, I had a concealed carry permit, believe it or not. And I've never had any difficulties or entanglements. I mean, no one's ever made me as carrying a gun. I've never been in a situation where I came close to having to go to that gun. I've been in situations where I was darn glad I had the gun, and then I immediately removed myself from that environment. Anytime you're happy you have the gun, that's a good indicator that you ought to leave wherever you are. Um, but where I see people typically getting into serious trouble carrying guns is when the gun is the only defensive tool they have. They got that concealed carry permit, they strap the gun to the person, they go out in the world and they feel like now they're prepared to defend themselves against anything. And that's just not true. The gun is rarely the appropriate option in a real world confrontation or real world situation. It's rarely the answer to the problem. Now, when it is the answer, it's generally the only answer, but it's rarely the answer. I mean, if you look at the Department of Justice crime statistics, you're 5 times more likely to be faced with a simple assault or a simple battery, a non-deadly force attack, than you are a deadly force attack. And you can't go to the gun to defend against a non-deadly force attack. But that's what I see people doing. If the only defensive tool they have is a gun and they get genuinely scared by a non-deadly force attack, they go to the gun. And then they get charged with aggravated assault with a firearm because they were not justified in using force, or heaven forbid, they actually used a gun and killed somebody. You don't have a legal justification for that use of deadly force against a non-deadly force attack. I think that'll be the primary issue in this Edgecombe case up in Wisconsin, where the defendant shot the lawyer in the face. There appears to have been some kind of ongoing, maybe mutual combat confrontation going on between these two men that evening as they traveled down the street. The defendant on a bicycle, the lawyer, I guess, was a passenger in a car being driven by his wife. But whatever that prior confrontation, at the moment the defendant fired the shot into the face of the lawyer with fatal effect, he needs to have had legal justification for firing that shot, which means he used deadly defensive force. He needs to show he was facing a reasonable perceived deadly force threat. And I think that's going to be difficult to do, in which case he doesn't have a legal justification for that use of deadly defensive force. And it should be a pretty straightforward conviction. So just be careful you don't put yourself in a position where your only defensive tool is the gun. You know, if carrying a gun is something you want to do, and as I say, I've done it my entire adult life, also have some non-deadly force option, whether it's pepper spray, bare hand skills, something that you can use to effectively defend yourself against that more common non-deadly force threat. If all you have is the gun, the emotional driver to go to that gun when you're frightened by a genuine but non-deadly force threat is pretty powerful. Does Kim Potter have a chance on appeal? That's from Rob. Yes, I think she has a very sound legal basis for appeal because the jury was misinstructed on what's required to convict on reckless manslaughter. That said, appeals are for losers. Literally, it's for people who lost at trial. And it's, many people have the idea that an appeal is like a do-over of the trial, and it couldn't be further from the truth. All the legal presumptions that were in your favor at trial, and they were all in your favor. You're presumed to be innocent until proven guilty beyond a reasonable doubt. So all those legal presumptions at trial are in the defendant's favor. Well, on appeal, they're all against you. Now that you've been found guilty by a jury, it's presumed that you're guilty. Plus, there's a lot of other complications. You can't, at trial, you can argue basically the entire spectrum of legal issues in the case. On appeal, you can only argue the ones that were preserved for appeal or are of constitutional import. So those don't necessarily need to be preserved. But most of the legal issues you might appeal have to be preserved at trial, usually by an objection. Fortunately, that was done by Kim Potter's defense at trial. So they objected to this misstatement of the law. So it is preserved for appeal. And you have to hope that the appellate courts care, that they want to address that particular issue. Now, if they do, I think Kim Potter has a very, very strong basis for appeal on the legal merits. But it's appeals are always a high risk endeavor. Virtually no appeals result in a reversal of a conviction, folks. Almost none of them. Very, very small percentage. And when they do, it's not like you're suddenly found not guilty by the appellate courts. When you do get a reversal, typically you're just going back for another trial. They're going to retry you at the trial court, usually in front of the same judge, with a different jury, of course, but usually in front of the same judge, And the second trial is just going to be conducted according to whatever correction that the appellate court said had to be made to correct for the error in the first trial. Now, one thing in Kim Potter's favor is the correction that would be made here would be correcting this misstatement of law of what's required for reckless manslaughter. And I believe if the jury's given a correct statement of reckless manslaughter, and that statement would include that Kim Potter had to know that she had a gun in her hand, that she consciously disregarded that risk. And nobody argued that at all at trial. There's no evidence of that. Everyone believes she herself believed she had a taser in her hand, not a gun. She had no idea she was creating a risk of death and disregarded that risk consciously. That simply didn't happen here. There's no evidence of that. So if Kim Potter gets a correct statement of the law, frankly, it's not worth trying her again. I don't think any rational prosecutor would believe they could get a conviction on that with a correct reading of the law on reckless manslaughter. So in Kim Potter's case, what I would expect is that the appellate court would reverse. They'd grant her a new trial. And if you had a rational prosecution, they wouldn't do the new trial, because under the correct statement of the law, they couldn't possibly prove her guilty of reckless manslaughter beyond a reasonable doubt. But they may do it anyway. Obviously, prosecutors do sometimes bring cases for political purposes. Mark asks, in the Ahmaud Arbery case, there was a predicate. So in the Ahmaud Arbery case, the defendants were charged with multiple felony murder counts. Felony murder is predicated on some underlying felony. One of the underlying felonies in that case was this attempted false imprisonment. And Mark's basically asking, well, but what if they didn't know they were intending to make a false imprisonment? They thought they were making a lawful citizen's arrest. Let's assume for argument's sake. And I think that's probably true. So when the law is talking about intent, the intent need not be that you know you're breaking the law or that you know you're doing something unlawful. Ignorance of the law, mistakes of the law are no defense. So if you think you're doing something lawful, but you're actually violating the law, well, then you're violating the law. What matters is not some intent that you're violating the law. What matters is that your conduct was intentional, whatever you're doing. So, for example, if you have a concealed carry permit in Pennsylvania and you, unknowingly cross the border into New Jersey while in possession of that gun, maybe you got on the wrong bus and were reading a newspaper and you had no idea you were now in New Jersey. So you didn't intend, and you don't have a carry permit in New Jersey, of course. So now you're in unlawful possession of a gun in New Jersey. It doesn't matter that you didn't intend to be in New Jersey with a gun unlawfully. What matters is that you knew you had a gun and you were in New Jersey. That's all. So that's the intent we're looking at. It doesn't require some particular knowledge of the law. It only requires that your conduct itself was intentional. Let's see. Do Good Samaritan laws obligate me to use force to defend another person? That's asked by Nelson. No, you don't have, of course, this is all under American law. I know we have participants here who are from other countries, and welcome, but I don't know anything about about use of force law in other countries. But in America, you don't have any legal obligation to come to the defense of somebody else, to rescue somebody else. The only exception would be if you created their risk. So if you push someone off a bridge and they fall in the lake and they're drowning, because you created their risk, you would have a legal duty to try to rescue them. But if you're just walking along the side of the lake and you see someone in the lake drowning, you're under no legal obligation to go rescue them. Now, if you do rescue them and some harm results, say they fight you while you're saving them from drowning, and you end up injuring them unintentionally in some way, it's possible. It sometimes happens that people sue over that, believe it or not. And a Good Samaritan law could protect you from such a lawsuit. So that's how Good Samaritan laws work. They don't oblige you to come to anybody's rescue or defense, but they say if you're making a good faith effort to rescue or defend somebody and some injury results in that process, a Good Samaritan law would protect you from legal liability for that unintended incidental injury. The same could happen, for example, if you're giving CPR to someone, so someone's not breathing, you give CPR, chest compressions, and chest compressions done right, folks, can really hurt the ribs, can damage the ribs. So in theory, you could save that person's life, and then they want to sue you because they had medical bills because you cracked a rib on them when you're doing the chest compression. So Good Samaritan law would protect you from that liability because you were in good faith providing CPR to save their life. Let's see. So someone asks, in defense of others scenario, if you come upon a person being beaten so severely that it's a deadly force attack, right? So it's not just a traditional fist fight. They are reasonably likely to suffer death or serious bodily injury because of the nature of this attack. You come to their defense, and then it turns out that they were actually the initial aggressor in that confrontation. Really what we're doing here is a straight up self-defense analysis. So what would have been their privilege to use force in self-defense? If they had been an initial non-deadly mutual combatant, it started as a traditional fist fight with no real threat of death or serious bodily injury, and then the other party escalated it to a deadly force type of attack. If they were a non-deadly force mutual combatant and the other party escalated to deadly force, arguably they've regained a privilege of self-defense against that deadly force attack. And then you would have that same legal privilege that they would have to defend themselves against that deadly force attack. If they were the initial deadly force aggressor or a mutual combat deadly force aggressor, they would likely have no privilege of self-defense. I mean, they attacked someone with deadly force or engaged in deadly force mutual combat, and they're losing that fight. They would likely have no legal privilege of self-defense because as a mutual combatant, they've lost innocence, or initial aggressor, they've lost innocence. So I'm not sure why you would expect a legal privilege to kill that other person, use deadly force against that other person if they don't have it themselves. Very dangerous to come to the defense of other people, folks, especially if you turn a corner and stumble upon the confrontation and don't really know how it started. Let's see. Dave asks, say a defendant submits evidence in court to prove training, prior knowledge. Wouldn't that person then need to testify to confirm authenticity in order for it to be accepted? No, not necessarily, Dave. This is in the context of getting specialized knowledge admitted into evidence. In other words, admitted before the jury. Things like the tool or drill, things like how dangerous knives are, whatever kind of training you may have taken in self-defense, things like a law of self-defense class. In order to get that into evidence, and so the jury can hear it, you have to be able to demonstrate that you possessed that specialized knowledge, whatever it is, at the time you acted in self-defense. You don't need a lot of evidence of that. You need basically more than zero evidence. So class certificates, class syllabus, slides, that would all be almost certainly sufficient to demonstrate you had that knowledge. Now, to actually, a piece of paper in front of a jury isn't very informative. Someone would have to explain what was actually learned in that course, right? That's the knowledge you actually want the jury to hear. And you could testify about that yourself if you were willing to take the witness stand, but you don't need to. For example, you might have the actual instructor come in to testify about what was taught. And he would also be testifying to the authenticity of the syllabus and the certificate and all of this. You could, if what was taught were commonly accepted concepts in the self-defense community, you could really have any use of force expert come in to testify about that. So if the issue was the tool or drill, well, anyone who teaches the tool or drill or has expertise in it could come and testify about that. It wouldn't have to be you personally. It wouldn't have to be your particular instructor. I will say, however, there's a lot of crazy instructors out there, folks. And I'm not suggesting you shouldn't take one of their classes. This is particularly true of a lot of knife instructors. I don't know why. And I don't mean to criticize them or suggest you shouldn't take instruction in knife defense. You absolutely should. Knives are very effective and extremely dangerous close quarters weapons, and it would be good to be trained in their use and defense for lawful purposes. But keep in mind, if you're getting instruction from someone who comes across as a little bit crazy or has a sketchy social media history, profile, that would be an awkward person to bring in as an expert witness, because all of that will be exposed on cross-examination, used for impeachment of that witness. So I'm not saying don't get trained by those people, but you might want to also make sure that you're also trained by people who come across as professional, as presentable to a jury, and don't have a sketchy social media profile. So those would be the people you would preferentially choose to be the expert witness in your case, even though you got training from lots of people. Let's see. William asked a question about being attacked in your car, like by a carjacker. I spoke to the car defense issues at length over the last couple of days. What about the use of pepper spray to defend personal property? What if that escalates the level of force of the aggressor? Well, pepper spray is non-deadly force. You can use non-deadly force in defense of personal property, least defensible property. So we're talking here not your castle, not an occupied car, like a laptop or a coat or just personal items, or open property, open terrain. Someone's committing a simple trespass. Now, within that bucket of non-deadly force, there is a continuum of degrees of force, and you do have to maintain proportionality within that continuum. So you can't just necessarily bump to the highest degree of non-deadly force. And pepper spray is a pretty high degree of non-deadly force. It's really just short of deadly force. So it's not necessarily the first thing I would jump to. You might try other options. It depends on the, as they say, the totality of the circumstances. And frankly, to my mind, it depends on the nature of the personal property. I mean, I'm strongly disinclined to use any degree of force in defense of personal property, in part because it can escalate. Well, first of all, is it your personal property or someone else's personal property? Because you don't always have a privilege to defend someone else's personal property. So that's the first question. Some woman screams, "Oh, that guy grabbed my purse," and there's a dude running down the street fleeing with the purse. You may have no privilege to use force in defense of her personal property. But even if it's your personal property, the fight could escalate. Now, if it escalates on the part of the other person, they don't like getting pepper sprayed, so they pull out a knife, say, that escalation is on them from a legal perspective, but it's on you from a physical perspective. Now you're in a knife fight. How much personal property, what kind of personal property do you have that's worth the risk of getting in a knife fight? I don't have, there's not a lot of reasons I would get into a knife fight. It's difficult for me to imagine any reason involving personal property. Now, I'm not telling you not to use force in defense of your personal property. Listen, I understand people work hard for their personal property. It's an investment of their time, of their life into that personal property. But these are the real legal and physical risks you're incurring when you do that. I'm not telling you not to do it, just trying to encourage you to make an informed decision. Let's see. Ryan asks, some states have soft stand your ground. It can be argued. So these are stand your ground states where the prosecutor cannot argue that you had a legal duty to retreat, because you don't in a stand your ground state. But in the soft stand your ground states, a prosecutor can argue that, look, you didn't have a legal duty to retreat, but you could have retreated and a reasonable person would have. And self-defense has to be reasonable. And therefore your failure to retreat was unreasonable. And therefore you fail self-defense because you engaged in unreasonable conduct. That's an argument prosecutors are allowed to make in the soft stand your ground states. So it's kind of a backdoor attack on your failure to take advantage of a safe avenue of retreat, even though you're in a stand your ground jurisdiction, a soft stand your ground jurisdiction. The hard stand your ground states take avoidance completely off the table. The jury's not allowed to consider the possibility of retreat in evaluating the reasonableness of your defensive conduct. But there's only 7 or 8 of those, and there's 39 stand your ground states. So most of the stand your ground states, roughly 30, are soft stand your ground states. And Ryan asked, would that also apply in your house? Well, people often conflate stand your ground and castle doctrine. Castle doctrine, properly understood, relieves you of an otherwise existing duty to retreat if you're in your home. Stand your ground kind of does the same thing when you're out of your home, right? When you're in public, stand your ground relieves you of an otherwise existing duty to retreat. So they're similar legal doctrines, but they're not identical. A lot of stand your ground is um, contingent on meeting certain legal conditions, like being in a place you have a right to be, not being engaged in unlawful activity. In Pennsylvania, that your attacker presented a deadly weapon, that's a condition for stand your ground. Very odd one, but there you go. And it's the kind of compromise you sometimes get when stand your ground is based on legislation that had to be debated and argued before it was passed. Um, and castle doctrine doesn't have those conditions, but castle doctrine can have other conditions. It can have conditions like it applies to you're relieved of that duty to retreat in your home if you're defending against a genuine intruder, but not if you're defending against a co-dweller, so a spouse or someone who also lives in the castle. So they each have different conditions that may apply, and which can result in the loss of that relief from a duty to retreat if those conditions don't apply, if the boxes aren't checked. In this particular case, the reasonableness attack that's available against stand your ground in a soft stand your ground state would not be applicable in the castle doctrine context. You'd be dealing strictly with whatever flavor of castle doctrine you have in your state. At least I don't think it would be permissible. You always have the risk, folks, that even when on the legal merits, an argument ought not be permissible, that the prosecution is going to make it anyway, and that the judge will allow it. So I always encourage people, just imagine whatever your self-defense case is, that all these variables in the system, all this noise in the system will work against you, that you'll get the worst of all the judgment calls, the worst of all the flavors of castle doctrine, or the most limited scope of stand your ground. All these things. Assume the worst and conduct yourself in self-defense in such a way that you're hard to convict, even if those judgment calls go against you. Let's see. Highly defensible property. So what if you come home, you weren't home, you come home and there's already somebody in your house unlawfully, and they broke something to get in. So you have a forcible and unlawful entry into the home, but you were not in the home when it happened. Well, if you're not in the home, obviously you're not defending against that intruder from within the home. You get home later and find this person in your house. Can you engage them with deadly force? Now, first of all, I'm presuming you would have reason to know there's no one else in the home either. If there's other people in the home, then it's an occupied home, occupied highly defensible property. It's really much the same situation as if you had been in the home yourself. Remember, these special provisions for the defense of highly defensible property, like your home or your place of business or your occupied vehicle, the reason those special provisions exist is because it's not to protect the actual physical structure of the home. Nobody cares about that. That's inanimate property. It's because the home has or that property, highly defensible property, has as a core function the shelter and protection of people. The property, the highly defensible property, is being treated as a surrogate for the people inside the property. If there's no one inside the property, it's really just personal property. There's no legal rationale for changing the standards for the use of deadly force if we're talking about an empty home. So I'll presume for purposes of this question that the home is empty, except, of course, for the unlawful intruder. And then you go into the home. Would that be treated the same way as if you had been in the home when the forcible entry happened? Well, first of all, I think we realistically need to address this both from a legal and a practical, physical perspective. Why would you do that? Why would you go to a fight, go to a gunfight, when you don't have to, when there's no existing threat to human life? So you know your home is empty. You know there's a bad guy in there who broke in, and you're going to go in there and engage them with deadly force? Let's assume it was perfectly lawful to do that. Why would you do that? Why would you go to a gunfight you don't have to go to? And there's no magic pixie dust that says you win that gunfight. You're willing to die over that, as opposed to simply calling the police and waiting outside until the cops show up, and then they can go in with their shotguns and dogs and backup and body armor, do the stuff we pay them to do with their qualified immunity. So I would just tell you, don't do that. It's not worth the risk if there's no threat to innocent human life. If you do go in, I think a prosecutor would argue that it ought not be the same as if you had been in the home when the home was invaded, because you went to the fight. And when you go to the fight, as opposed to the fight coming to you, it rarely looks like self-defense to anybody. So that's the risk you're running, that the prosecutor will make that argument. Remember, at the end of the day, if you've killed somebody, you use deadly force against someone, you have to presume they're going to die as a result. You've killed someone. The jury really wants to know why that had to happen. It can't have been optional. It can't have been a coin flip. It can't have been a personal preference that you took another person's life. It has to have been necessary, reasonably necessary. And going to an empty home to gun down an invader in that home doesn't strike me as a compelling argument of necessity to a jury. Steve asks, doesn't burglary not involve another person? So this would have come up in the probably when we talked about the Texas law that allows for the use of deadly force in defense of mere personal property. This is Texas Penal Code 9.42. If you'd like to read that statute, it's the only state in the country that allows for deadly force in defense of mere personal property. You can find that statute at lawofselfdefense.com/942. And in that, they list there's enumerated lists of criminal offenses that would justify the use of deadly force in defense of mere personal property. And most of those offenses are actually offenses against persons. There are things like robbery. Well, robbery is taking property from a person under threat of violence. They also list burglary, and I really characterize burglary as also a threat against persons. Now, technically speaking, that's not an element of burglary. Burglary is, unlawfully trespassing into someone's property with the intent of committing a crime, usually theft. But the reason burglary is treated as seriously as it is because there's an implicit threat to persons. The risk to anybody the burglar would stumble across in the home is so great, recognized as being so great, that's why burglary is treated as serious a felony offense as it is. I mean, the New York State, for example, burglary is explicitly a permissible event for the use of deadly defensive force. If it's a burglary, you can use deadly force in New York State. The statute lists it explicitly. So although technically it's a property offense, practically it's really an offense against persons because it's the risk to persons that makes the crime of burglary so serious. Barry asks, I live in a 2-story house with a bedroom on the 2nd floor. I hear glass breaking downstairs. There's an intruder in the house downstairs. Tactically, we teach in our courses that it's best to shelter upstairs and wait for police. If I go downstairs and engage, can I be considered the aggressor? Would a prosecutor argue that? Could a prosecutor argue that? Maybe, but it's not very compelling. You have a right of exclusion throughout your home. It's your home. You can go anywhere in your home. I would suggest that it would be imprudent to do that, just like I would suggest it would be imprudent to go into an empty house to chase down and gun down a forcible intruder in that empty house. In my own home, our policy is, as you say, you teach that we stay on the 2nd floor. And those intruders on the 1st floor can steal anything they want from the 1st floor until the cops show up, I guess. I'm not going down there. There's nothing on the main floor I'm willing to kill over. There's certainly nothing on the main floor I'm willing to die over. All our bedrooms are on the 2nd floor. What those intruders cannot do is come up the stairs. If they come up the stairs, I will try to dissuade them verbally from doing that. And if they insist, I might get loud and flashy. That's our red line. But would it be credible for a prosecutor to try to sell to a jury that if you did go downstairs, you were engaged in misconduct, you were the aggressor? No. The initial aggressions already occurred when they forcibly entered your home. Michael asks, does the Texas statute 9.42 apply to pets? It applies to any personal property, and pets are mere personal property in the eyes of the law. I know those of you who have pets feel they're as much a member of your family as the humans, maybe more than the humans, I guess, depending on the humans in your house. Legally, pets are merely personal property. Usually, in most states, 49 states, everything besides Texas, only non-deadly force in defense of property. That would include your pets. In Texas, 9.42 allows for the use of deadly force in defense of property if the necessary conditions are met. Go look at that statute, lawofselfdefense.com/942. You'll see a lot of conditions that have to be met. And if you don't meet any one of those conditions, you don't qualify for the defense. And then your use of deadly force was not legally justified. But technically, 9.42 would apply to pets in the same way it applies to every other form of personal property in Texas. Do you have a duty to call medical attention to someone you shoot? Maybe. I mean, I would argue as a strictly legal matter that you don't. But again, I mentioned earlier, you generally don't have a legal duty to rescue or come to the defense of others unless you caused their risk. Now, what the law is contemplating there is that you caused their risk in some unjustified way. When you've shot someone in lawful self-defense, arguably you caused their risk, their harm, in a justified way, and there ought be no legal liability for justified conduct. So I would argue that you don't have a legal duty to provide aid. Certainly, you would not have a legal duty to provide aid at your jeopardy. I guess if you're just calling for aid, you're not incurring jeopardy necessarily. I would still argue you don't have a legal duty to call for aid, but it would be a good idea for a number of reasons. One is you don't want that person to die. If consistent with safety, you can help keep that person from dying, that's almost invariably going to be good for you. First of all, you won't have killed somebody, which is a good thing, assuming it didn't have to happen, right? The death didn't have to happen. Your safety was already secured. That's conditional throughout my comments here. Consistent with safety. But if that person dies, suddenly your legal liability skyrockets. Instead of looking at merely, say, at worst, an aggravated battery charge, which is a serious charge, if they live. But if they die, you're looking at murder or manslaughter. You're looking at the possibility of life in prison without early release on the table, without parole on the table. So do you want that increased liability? If you can avoid that increased liability consistent with safety. So I generally argue that you don't want that person to die. You want them to live, if only in your own interests. And therefore, calling to make sure they get aid is something I think would be prudent to do. In fact, when we talk in our Law Self-Defense Advanced class about interacting with the police in the aftermath of a use of force event, one of the things we talk about is when you call 911, assuming you call 911, when you call 911, ask not just for police, but also ask for an ambulance. And one of the reasons you want that ambulance to get there as quickly as possible, which is why you're asking for it up front, is to try to help prevent that person from dying. Maybe you had to shoot them in lawful self-defense, but it's still in your interest, generally speaking, that they don't die, assuming you can have that outcome, that non-fatal outcome, consistent with safety. Let's see. Is remorse an admission of guilt in a self-defense case? No. You're allowed to feel bad that you had to shoot somebody and wish you didn't have to shoot them. That's not an admission that what you did was unlawful. Might a prosecutor try to suggest that it indicates that you thought you had done something wrong? Like in the Kim Potter trial, she immediately after shooting Dante Wright and he drove off, she announced on body camera, "I'm going to prison." That doesn't mean she thought she did something unlawful. It could have meant that she thought in the current social environment, she was likely to be unjustly convicted of a crime and sent to prison. Nevertheless, can the prosecutor talk about it in the sense that not really an admission of guilt, but an admission that she thought she had done something wrong, not necessarily criminal, but wrong? The prosecution did make that argument. Erin Eldridge made that argument in her closing to the jury. Really, and of course, she did do something wrong, right? I mean, she used a gun instead of a taser unintentionally. She made a mistake. So, strictly speaking, it wasn't wrong for Eldridge to say that. Of course, what Eldridge was really trying to communicate was not just that Kim Potter had done something wrong, but she had done something legally reckless and therefore should be convicted of reckless manslaughter. That's not true, but the prosecutor was allowed to make that argument. And then, of course, the other prosecutor on rebuttal argued Matthews argued to the jury that all that was required for reckless manslaughter was negligence, not recklessness. So, again, prosecutors can make these kinds of arguments even if it's not legitimate on the legal merits. You hope the judge would correct, but sometimes they don't. And then you can get an unjust conviction like we got in the Potter trial. Harriet asks, if you claim self-defense immunity, and that's normally claimed in a pre-trial hearing, if you claim self-defense immunity, you have that hearing, and the judge decides against you, does that preclude you arguing self-defense at trial? No. Two completely separate proceedings. Of course, if you win immunity, there is no trial, presumably, if you're granted immunity from criminal prosecution. So if you win immunity, it's all over. If you lose immunity at the hearing, then all that happens is you go on to trial. Because keep in mind, usually to get self-defense immunity at the hearing, the pretrial hearing, you have to prove self-defense by a majority of the evidence. But the standard is different at trial. At trial, the prosecution has to disprove your claim of self-defense beyond a reasonable doubt. So logically, it's quite possible. Say, let's imagine that your argument for self-defense is 40% of the evidence. That's not a majority. That's not enough for self-defense immunity, but it's much more than a reasonable doubt. So it's more than sufficient to win an acquittal at trial. And you would be able to argue self-defense at trial. Let's see. Boy, that question was answered by several people, asked by several people, but now it's been answered. Let's see. There's some questions here about how to prepare for an arrest after an incident, a use of force event. Should I have a bail bondsman card in my wallet? Can I pay bail with a credit card? Folks, all these are such jurisdiction-specific questions. How bail works varies a lot from state to state. Some states, you have to have the absolute amount of the bail. Other states, you can use a bail bondsman. Not every state has bail bondsman, folks. But in some states, you can use a bail bondsman where they put up the total amount of the bail and you pay them 10%, which they keep. By the way, that's their fee for putting up the total. If you put up the total of bail yourself and then you meet the conditions of bail, you appear in court and so forth when you're supposed to, you get 100% of your money back. If you use a bail bondsman, you pay the bail bondsman 10%, and that's gone forever. That's his fee. But the bottom line is, I wouldn't try to prepare for any of that. It doesn't matter what the process is in particular, because whatever the process is what it is. You'll be informed of what it is at the time, and then you'll do whatever it is they allow you to do at the time to get out of jail. Obviously, the more resources you have personally, the more money you have or property you have, or the easier it would be for you to make a high level of bail. Or if you're a member of a good quote unquote self-defense insurance program, typically they will cover your bail, sometimes up to some certain dollar amount. And if you're interested in those kinds of programs, the only one we recommend that people look at whichever ones you want. I encourage you to look at all of them so you can make an informed decision. But the one quote unquote self-defense insurance provider, legal service provider that we recommend, the one I'm personally a member of, is at lawofselfdefense.com/CCW safe. So there's some of these issues, folks, that like bail, they're not really in your control. You don't have decision-making options there. The process is going to be whatever the process is. Where we try to focus on at law of self-defense is where you do have decision-making options and therefore help guide you in making optimal decisions. Where there are no decisions to be made, we're not going to teach how bail is done in 50 different states, because it's just not a productive use of our time or your time. Mark asks an interesting question. So there's a burglar in my house. while he's present, but he slips out a window, finds the burglar's vehicle, and puts a couple rounds into the engine block to prevent his flight. Is it illegal to use the weapon to disable his car? I mean, I, I don't know, I guess. Maybe not. You could argue the necessity defense that, of course, normally shooting another person's car would be unlawful. You're damaging someone else's property. But is the harm of that damage less than the harm of allowing him to flee? I guess you could make that argument. The balancing of harms test, and therefore not as an act of self-defense, not using the legal justification of self-defense, but the legal justification of the necessity defense or the doctrine of lesser harms, that you had a legal justification for firing into his car. But anytime you fire rounds in public, folks, you're raising a serious risk of facing reckless endangerment charges, even if you don't actually hurt anybody. Bullets do weird things when they hit things. When they hit hard things, when they hit soft things, they go in different directions. They ricochet in unpredictable ways, and they're dangerous. So very common, for example, when people use guns to fire a warning shot or to shoot at an aggressive animal, that one of the charges they end up facing is reckless endangerment if there were innocent people in the environment that could have been injured by those rounds. And again, I would have to ask, really, why? If there's a burglar in my house and then he's prepared to leave, that's what I want. I want him to leave. I don't care really about the property. That's what I have insurance for. I care about innocent life, my life, the life of my wife and my children, and that is best secured by that bad guy not being there anymore. So if he's willing to get in his car and drive away, even if it's with a bunch of my property, that's what I want. I don't want to trap him by my home. And by the way, what's he going to do then? His car doesn't start. Is he going to try to take your car then? Come back into your home to take your car? Then what? Then you're in a gunfight? You think about the mission, folks. The core mission is securing your safety and that of other people you have a duty to protect. Aggressively engaging bad guys is not the formula for success if that's the mission. You want those bad guys to go away. Let's see. Samuel writes, I was advised by my attorney to call her and then she will call 911 for me. Is that reasonable? I mean, I guess so. Most people don't have an attorney. So I'm not sure what you mean by my attorney. Unless certainly most people don't have a criminal defense attorney, unless you're a criminal. If you're a criminal, you probably have existing relationships with criminal defense attorneys. Most people don't have a criminal defense attorney. Can they call 911 for you? Sure. I mean, would she have the necessary information? I guess you'd have to pass it on to her, the location, a general sense of what happened. Um, there's nothing wrong with that per se. Would the prosecution be allowed to talk about the fact that you called your attorney first? Probably not. That would probably be privileged. You would characterize it as an assertion of your right to counsel. Certainly, I would, and make that privileged. Kyle asked, for the 911 call, what's your opinion on having a third party call instead of you? Well, first of all, I don't think you may not have any control over that, right? I mean, if there's other people around and there's gunshots, for example, it's quite likely other people are going to be calling. You don't know what they're telling 911. It may be an accurate rendition or not of what happened. They may not be favorably disposed to you. You might have just shot their friend and now they're calling 911, right? That's a possibility. If you're with somebody who's with you, your wife, for example, would you have her call 911 instead? I mean, maybe. Is that supposed to avoid the risk of you saying things that would be incriminating on the 911 call? Are you avoiding that risk if there's a risk of your wife saying something incriminating? And that's another issue we talk about in the class, folks, is when we talk about interacting with the police, we spend almost an hour talking about that. And so the students presumably now have a lot of insight into whether or not they might want to talk to the police and in what way and what they might want to say. But if there's any prospect that you might have to defend yourself in the company of your own family members, are they going to be talking to the police? Do they have this lengthy, detailed context about what to say or not to say? I mean, if they weren't in the class, they don't. unless, of course, you have that conversation with them. So I would urge you, if you're going to have someone like your wife call 911, that she be as informed about how to do that, consistent with safety and your legal defense as you are. Otherwise, you might well be damaging yourself by having, and I don't mean this in a derogatory sense, I mean this in a technical sense, by having a naive and ignorant person make the 911 call on your behalf. I don't mean they're bad people for being naive and ignorant. I mean, they literally don't know what it is they're supposed to be doing on that call in an optimal way because they weren't in the class. So I would encourage you, if you're thinking of having that done, then, make sure they're doing it in as informed a way as you would be doing it, assuming you've taken the class. And by the way, of course, the class is over, folks, so you can't take the live class now, but we do have a very special offer we're running just for the days that we're answering the last of these Q&A questions. We call it our Rittenhouse bundle because we launched it right after the acquittal of Kyle Rittenhouse, and we resurrected it for these Q&A sessions. You can get 4 of our best-selling courses for just $200. Normally, that advanced class, the online streamed version of our full-day advanced class that we taught this past Saturday, normally that advanced class by itself is $200. And then it would be a total of $500 to get all 4 of these classes together. With this bundle, you get all 4 of these courses for just the $200 you would normally pay for the advanced class by itself. So you're saving yourself $300 with this bundle. And I'm wrapping up these Q&A sessions, live streams today, folks. That's 3 days in a row is enough. So today is the last day that this is going to be on the table. If this is of interest, and it ought to be, you can take advantage of this at lawofselfdefense.com/bundle. And today's the last day. So 4 of these classes, normally $500 for the group, just $200. Just the price of the advanced class by itself normally is $200. But with this bundle, you can get all 4 at lawofselfdefense.com/bundle. Okay, back to the questions. And by the way, folks, if you're watching this live and you have questions you'd like to submit, you can do that as a super chat. Before we close out today, I will scroll through all the super chat questions submitted and answer them as well. Let's see. Okay. Emily just rushed into my office. What am I supposed to do with this now? Hold on one second, folks. So, folks, one of the consequences you get by having a boomer lawyer do live streams on YouTube is I don't really know how the technology works. So I spoke for about 2 hours yesterday in yesterday's live stream, and it looked to me like I didn't have any super chat questions from yesterday. I'm told I am mistaken about that. There were super chat questions. I just didn't see them for some reason. So Emily has compiled them. So before we close out today, I will answer not just the super chat questions you submit today, but also the super chat questions that were submitted yesterday. Hopefully those people are watching this live stream as well. If not, they can catch the recorded playback after the fact. All right, let's see. Yeah, so I mentioned you want to, in the aftermath, when you call the police, you want to request not just police but also an ambulance. One reason for that is that you don't want that other person to die if you can help it, if only for purposes of your own legal liability. But you also don't know if you've been seriously injured. You could have been shot or stabbed, be bleeding out, and not know it in the immediate moment, given the adrenaline, the stress, all of that. So you want that ambulance there as quickly as possible for your own benefit as well, so professionals can examine you and make sure you're not seriously injured. And when I tell this point in class, I share an anecdote from my own experience. I was once cut down the length of my arm to the bone. You could look at the cut and just see the bone in there. No blood for some reason. It was like a piece of cold meat was cut. But I had no idea I was cut until somebody told me. I felt something. I felt like a blow, but it was a fight. So I had no idea that I'd been cut, especially not that seriously, until someone mentioned it to me. And someone asked here in the questions, what was the deal with that cut to your arm that you talk about? That was it. It was a fight as a kid with people who were a lot more dangerous than I thought they were. One of the risks of getting even into what you think is a non-deadly force fight, folks, is that it may not stay that way, right? You have no control over that. The other person can escalate. Thankfully, it was just a cut to the arm, pretty long cut, but it was just a cut that healed just fine with no complications. But, that cut to the neck would have been a, game ender. So we always have to be aware of those kinds of risks. The best way to win a fight, folks, is to not be in the fight. If you can avoid being in the fight, consistent with safety. Amina asked, what's the best way to assert your rights? So at some point with your interaction with police, you're going to want to assert your rights. I call them the magic words. You need to assert your right to silence and your right to counsel. And you need to do that unambiguously, folks. An ambiguous assertion of your rights. I don't know if I should say anything more, or maybe I should talk to a lawyer. That's not a legally effective assertion of your rights. You need to do it unambiguously. I assert my right to silence. I assert my right to counsel. Let's see. William asks, essentially, do you only have to assert your rights once? Well, you only have to assert them once from a legal perspective to have asserted them. But when you're interacting with police, you may find yourself, you probably will find yourself interacting with different police at different times. Almost certainly you'll be interacting with first responders initially, and then investigative officers later, detectives later. And it's prudent to, if you want everyone to be aware that you've asserted your rights, because it changes how they conduct themselves with respect to you. There's no harm in asserting your rights again when there's a new person or there's somebody you don't know. Under the stress, you may not know that this was an officer you've already asserted your rights to. Feel free to do it again if they try to talk to you about what happened, for example. If you have video, audio, photo evidence, should you volunteer that evidence or request a warrant? If you were to allow police to view a video on your phone, can that be done without having to surrender your phone or allowing access to everything else on it? If your phone has evidence on it, and the police know that, they're going to take your phone. Now, might they need a warrant to take your phone? Sure. And they'll get it. If you've shot someone, they'll get a warrant to check your phone. And by the way, folks, they get everything. One of the first things that happens in serious use of force cases where a prosecution is contemplated is that prosecutor gets a warrant to all your social media, everything. And that goes right out to the social media services, and they'll get everything, including all the stuff you deleted. Nothing's ever actually deleted, folks. So they will get all of that. And often I see this stuff because it's shared with the defense in discovery. And if I'm consulting on a case, I get that evidence too, of course. And sometimes there's stuff on there that you'd rather other people did not see, or stuff that could be legally incriminating. Like, how do I hide a body kind of stuff. Excuse me. Sorry, we're deep into the second hour. My throat's going just a little bit. Thoughts on USCCA coverage, folks? I'm not going to do a deep dive on USCCA here. I do not recommend them for very specific reasons. If you'd like to hear about those reasons, I have done blog posts and videos on it. You can find that at lawofselfdefense.com/USCCA. I'm not telling you not to be a member of USCCA. If they're the best fit for you, then that's fine. I mean, it's your decision to make. But I personally do not recommend them. The one of these services that I do recommend, of which I'm a member, with whom I do quite a bit of partnering work, is CCW Safe at lawofselfdefense.com/CCW Safe. Can I recommend a pepper spray for daily carry? I have no particular expertise in pepper spray, but I do know people who have real expertise in pepper spray. One of those is Chuck Haggard. who teaches pepper spray courses. He teaches really, I think, every year at the at Tom Givens and Lynn Givens Tactical Conference, where I often speak. I spoke there last year. I'll be speaking there again this year. The Tactical Conference. I think if you Google TACCon, TACCON, Google should present you with the website. It might be sold out already. It sells out every year. But Chuck Haggard typically teaches there, and I've taken courses on pepper spray from him there. And he recommends the Sabre line of products. That's SABRE, and that's what I carry. Not because I have expert knowledge on it, but because I consider him an expert, and that's what he recommended. It's not the only one he recommends. There's another company with a kind of a more modern packaging. It looks a little fancier. I just don't remember the name of it. I'm sorry, but he also recommends that one. I know, but I would refer you to Chuck Haggard or someone of equivalent expertise. I personally carry the Sabre line of products, OC products. Vincent says, you do realize that BJJ is not the hands down best or the only outstanding jiu-jitsu school. I don't really know anything about jiu-jitsu, Vincent. I only mentioned BJJ because I happen to have come across the name. This would be in the context of having a diversified self-defense toolbox, barehanded skills, maybe one of those skills you want in your self-defense toolbox. And it could be anything. I mean, I don't care what it is. It could be high school wrestling. It could be BJJ. It could be karate. It could be taekwondo. I'm not an expert in any of those things. You would have to find something that you thought was most appropriate for you. And it's probably worth taking a look at a few different things. What do you do if your car is surrounded by a hostile mob? Well, folks, we have an entire course on that. Lawful defense against riots, looting, and arson. The mob dynamic is sufficiently different from a traditional self-defense scenario that we felt obliged to do a dedicated course on it. Normally, that course is, I forget how much it is. It's $50 or $100 by itself, but it's included in this Rittenhouse bundle. It's one of those 4 courses. Collectively, these 4 courses would normally be $500. So normally, Defense Against Riot, Looting, and Arson is a $100 course. For $200, you get all 4 of these courses. So again, if that's of interest and you would want in-depth instruction and in-depth context of how to defend yourself in those complicated environments like a mob environment, I would encourage you to take advantage of this bundle while it's available today at lawofselfdefense.com/bundle. Someone asked if we ordered the DVD, the state-specific DVD, does that have to be shipped? Well, if you order the DVD, it has to be shipped. But all these courses are also available as online streamed content. So you have the option to order. Well, some of them are only online streamed. You'd have to look at the specific product. I think the rioting course is only online. But most of them are DVD or online, or you can get both. If you get both, there's a substantial price discount. So you're not paying 100% for both options. If you get the combination of DVD and online stream, there's typically something like a 60% discount. And of course, the online stream then is instantly accessible. But naturally, the DVD is a physical product. It has to be shipped. And when you order the online stream version, you would get an email giving you the instructions you need to access that content. The online courses, by the way, usually come with a certificate option as well, which the DVDs really don't. But because the online content is set up like a classroom type of structure with different chapters, you finish each chapter, and then at the end, you have the option to get a digital certificate. Let's see. William asked, does carrying pepper spray along with your CCW, your gun, demonstrate an intent to respond with less than deadly force in the event you had to use deadly? I'm not sure I understand the question. If the question is, might a prosecutor argue that it wasn't really necessary for you to shoot that person because you could have used pepper spray instead? Yes, prosecutors can argue anything they want. The question is, how damaging is it likely to be, and how readily can your lawyer mitigate that kind of attack. Presumably, because you know the 5 elements of self-defense, you know what's required to justify deadly defensive force. If you've taken our course or gotten this bundle and watched that content or read our book, whatever, but if you know where the legal boundaries are and you use deadly force, presumably you used it within the legal boundaries and you're justified. You're not required to first have tried pepper spray if the conditions for deadly force self-defense are met. You can go to deadly force self-defense. That's what the law allows. In any case, the alternative to having both pepper spray and a gun is to not have both, is to have one or the other. And that, to my mind, is a vastly inferior position to be in. If you only have pepper spray, you don't have the gun. And while a gun is rarely the answer to the problem, when it is the answer, it's usually the only answer. So I want the gun anywhere I'm legally permitted to have that gun for self-defense purposes. On the other hand, I don't just want the gun because I know that I'm more likely to be subject to a non-deadly force attack than a deadly force attack. So I want the pepper spray too. The benefits of having both, to my mind, vastly outweigh whatever rhetorical argument a prosecutor might try to make. And remember, folks, at the end of the day, you'll never have done things right according to the prosecutor. Your gun was never the right gun. Your pepper spray was never the right pepper spray. Your bullets were never the right bullets. If they were hollow point, you should have used non-hollow point. If you used non-hollow point, you should have used hollow point. That's always going to be the case. That's just part of the nature of this adversarial process. There's no way to make yourself secure from those kinds of rhetorical arguments. You have to be prepared to counter argue them effectively. And a good lawyer ought to be able to do that. Someone here says they ordered the state-specific. They selected a state as part of the bundle, but they live on a border town, so they're commonly across the border in another state. You can order a second state completely separately. We sell the states individually as well as in bundles. You can do that at lawofselfdefense.com/state and order whatever individual states you want. I will note that the states are really a supplement. So if you don't have the advanced class already, that's 8 or 10 hours of content. The states, individual states, are like between an hour and 2 each. So they're on top, they're intended to be used on top of that advanced class, that longer length class. You can order the states separately without the advanced class, but then you're only getting the supplemental material. And that question was from Jacob. Maureen asks, you say that if there's an intruder in your home, they can take whatever they want on the first floor, but not come upstairs. Will you make it known to them to not come upstairs? If they give me the opportunity to let them know not to come upstairs, sure. I probably wouldn't say that until there was an effort to come upstairs. If they don't, I don't want to unnecessarily announce my presence or position. But if that's going to happen anyway, then sure, I would. If I had the opportunity, I would try to dissuade them. I would rather verbally dissuade someone than have to shoot them. So if the opportunity presents itself, I would attempt to verbally persuade. The same with verbal commands. If you were in a self-defense situation out in the street, you're not required to give any kind of verbal commands or warnings, folks. That's not part of the law. That's not one of the elements of self-defense. But if you have the opportunity to do that consistent with safety, why wouldn't you? If that could solve the problem. Now, it may not solve the problem. You may end up being compelled to go to physical force and self-defense. But if you could solve the problem with only words, that would be to your advantage. So Norman asks, you addressed CLE. CLE, folks, is continuing legal education. When we teach our courses live in person, we typically get them pre-accredited for CLE for attorneys in that jurisdiction. We don't do that for our online courses. It's just too complicated. But what we will do for lawyers who take any of our courses is if they would like a syllabus of that course content that they can use to self-report for continuing legal education credit, we're happy to provide that syllabus at no additional cost. But Norman asks, in his jurisdiction, apparently they could get credit if our courses were associated with a law school or accredited by a law school. Do we have any association with any law school? The answer is no. I do speak with some frequency at law schools as an invited speaker, but I have no association with any academic organization because I don't think much of most academic organizations, and they probably wouldn't think much of me. I don't think I would be a good fit for a modern day academic environment, including law schools, which, if you didn't know, law schools are about as woke can be. So I neither pursue and would be unlikely to accept any kind of formal association with any law school. And if I did accept, I wouldn't expect it to last very long. Let's see. John asked, is there a large difference between the laws of self-defense from one state to another? The answer generally is no. The underlying legal principles for defense of persons law, meaning defense of yourself and defense of others, is pretty much the same across the 50 states. It's those 5 elements: innocence, imminence, proportionality, avoidance, and reasonableness. Up to 5 elements. The most common difference in defense of persons law from state to state is that element of avoidance, whether they're a stand your ground state or duty to retreat state. There are 11 duty to retreat states. There's 39 stand your ground states where avoidance is not really applied in an otherwise lawful case of self-defense, generally speaking. So the underlying legal principles and the legal arguments you would make in court are essentially the same across the 50 states, with that notable exception of variance of that element of avoidance. Now, of course, that said, each state does have its own statutes, court decisions, jury instructions, and on the margins, on details, they can vary. Like the flavor of castle doctrine can vary, the conditions to qualify for stand your ground can carry, and those differences can make the difference between a guilty verdict and an acquittal. So I guess how I would put it is that, something like 80% of the law is the same across the 50 states, and about 20% of it varies. Most of that variance is the element of avoidance, but some of it is in marginal cases on some of these other legal issues. So the details do matter. The good news is that it's not like self-defense law is wildly different from state to state. So what I always recommend is that people adopt the most conservative, legally conservative self-defense strategies so that they would apply no matter what state you're in. So say you're in a hard stand your ground state like Texas, and you know that avoidance is completely off the table. The jury is not even allowed to consider the issue of retreat in determining whether or not your use of force in self-defense was reasonable. I would urge you, even in Texas, if you have a safe avenue of retreat, take it. Don't be in a fight you don't have to be in. And the nice thing about adopting that conservative approach is if you're doing that even where you don't need to, well, if you happen to be visiting Massachusetts for some ungodly reason, and you're attacked and you have to make decisions very quickly in self-defense, but hard programmed in your strategy is taking advantage of safe retreat, if safe retreat is possible, always, well, then you're good in Massachusetts as well as in Texas. You're good everywhere. So the advantage of adopting the most legally conservative self-defense strategies, to the extent consistent with safety, is that you don't have to spend much time thinking about, oh my gosh, are the rules different in this state? Because you've already adopted the most conservative view of version of those rules. So you'd be as far inside the legal boundaries as you could be, regardless of the state. Scott writes, this is his second time in the Law of Self-Defense Advanced class. By the way, people, we very frequently have people take that class 3, 4, 5 times because it is a fire hose of information. 7 to 8 hours of content, me talking at this pace for 7 or 8 hours, and people find that even though they paid close attention for that entire time, it's almost impossible to really absorb in long-term memory all that content in a single sitting. And they come back to the class and take it a second, third, fourth, fifth time, and they'll tell me after the 5th time, they'll say, I learned new stuff again. Even though the content is the same, I was able to focus on some of the aspects that hadn't stuck the first few times I took the course. Let's see. What else? And we're getting close to the point where I'm going to, actually, we're getting close to the end. We're in the high 400s now, and the questions are now becoming somewhat repetitive. Mark asks, is that Control Alt Revolt on your bookshelf behind me? That's the red book. Let's see, which shoulder? This shoulder. That's the red book up behind me. Nick Cole, one of my favorite authors. That's one of his books, Control Alt Revolt. Great book. I'm a big fan of all of Nick's work. He's an author, obviously. Writes very interesting stuff. So yes, that is that book. Let's see. John asks, if you have not established a relationship with a criminal attorney, how do you decide who to call when you are in lockup and give the one call? Well, first of all, you don't really get just one call, folks. They'll give you more calls. It'll just be at their convenience. So don't worry too much about that. And frankly, you don't have a relationship with a criminal attorney. You unless you're a criminal, normal people don't have an existing relationship with a criminal attorney. How do you decide who to call? For purposes of the immediate aftermath, I don't care who you call. What you're concerned about then is your initial arraignment, your hearing before a magistrate, where things like, they'll ask you if you plead guilty or not guilty. The charges against you will be specified. You'll be asked if you plead guilty or not guilty, and there'll be a discussion about bail. Any criminal defense attorney can handle that for you. So I don't care who you call. Call anybody who's a criminal defense attorney, and they do that stuff all the time. That attorney who handles that hearing before a magistrate, that doesn't have to be your attorney for trial. Maybe they're perfectly competent to arrange for bail, and they're not a very good trial attorney. So you can. What you want to do is get bailed out as quickly as possible, and then you can make an infinite number of phone calls or an infinite number of meetings with an infinite number of attorneys until you find the ones you're really comfortable with fighting for your life in court. George Zimmerman, for example, he went through a bunch of attorneys before he ended up with what turned out to be his dream team, legal defense team of Don West, who works, by the way, for CCW Safe as their national trial counsel. It's one of the reasons I'm such a big fan of CCW Safe. Consider them at lawofselfdefense.com/CCW Safe. And by the way, folks, the reason I tell you to do that instead of going to them directly is if you do that, you can get 10% off your membership with CCW Safe. We give you a discount code. You can LOSD10, LOSD for Law of Self-Defense, and the number 10. If you go through lawofselfdefense.com/CCW Safe, you can get a 10% discount off your membership there. But Don West is their national trial counsel. He was one of the defense team for George Zimmerman, along with Mark O'Mara. And those guys did a perfect legal defense. It should be taught in law schools all over the country. It should be required viewing for criminal defense attorneys or law students thinking of going into criminal defense. But they were not the first lawyers Zimmerman had. He had a bunch of lawyers before that. He went through a whole bunch of them before he ended up with that team. But the earlier ones could do the simple stuff early on. So it doesn't really matter who you call beforehand. It doesn't really matter if you have an existing relationship with an attorney. The best thing you can do for yourself in making sure you have competent legal counsel by the time you get to trial is exactly what you're doing right now, is learn enough about self-defense law. You don't have to become an attorney, but learn enough about self-defense law so that when you're interviewing attorneys, when you're considering attorneys to represent you at trial, you know what kinds of questions to ask, and you have some sense of what kind of responses you should get. So you're an informed consumer of that attorney's legal services. If you don't do this, and this is the minimum, listening to me talk on YouTube is really the minimum. You should read my book, take the courses, do all this stuff, have a really as in-depth an understanding of these legal issues as you can. If you don't do that kind of thing, any criminal defense attorney you talk to is going to sound brilliant because they know all the things and you know nothing. That's a very poor position to be in, folks, because I hate to say it, but like any other profession or trade, lawyers are on a bell curve, and some of them are world class, and most of them are somewhere in the middle, and some of them suck. You don't want the one that sucks because he'll just cash your check, lose your case, and off to jail you go. So you want the best attorney you can afford, and the best way to do that is to be an informed consumer. Frankly, another benefit of CCW Safe, in addition to getting the services of Don West, and I think any criminal defense who has Don West on their team is head and shoulders above not having him. Of course, that Don will be interacting with your criminal defense attorney, and if Don thinks that criminal defense attorney is sketchy, he will tell you that. Having Don West affirming that your attorney appears to know what he's doing, appears to be competent, man, that would be a huge confidence booster for me if I was an otherwise uninformed consumer of criminal defense services. Boy, I see the end of the list here. Let's see. Someone wrote, so this is really a gun law question, but I'll touch on it briefly. Razmek asks, what about someone who's a law-abiding person, but they're married to an ex-felon? So their spouse is someone who's been convicted of a felony. Now, if you've been convicted of a felony, you're a prohibited person when it comes to gun possession. You're not allowed to be in possession of firearms. What's that mean for the law-abiding person? Having a gun in the home or having ammunition in the home, because prohibited persons aren't supposed to have ammunition either. Sharing the same safe. The risk you run is that a prosecutor might try to argue that your spouse has constructive possession. They have ready access to that firearm. That qualifies as constructive possession of that firearm, and prosecute them as a felon in possession. That could happen. Now, it probably won't happen unless someone's keeping an eye on your ex-felon spouse, which I don't know. Presumably won't be the case. I don't know. But that is a legal risk you run. Now, if you can get past that and there's, say, a home invasion of your home and your ex-felon spouse picks up a gun in the moment to defend the home, defend herself, defend you, but only has possession of the gun transiently while in the act of otherwise lawful self-defense, and then immediately gives up possession of the gun after the need for self-defense is over, that transient possession would arguably be justified as self-defense, regardless of the general prohibition on a felon being in possession. A very common defense to felon in possession charges is that the possession was transient for purposes of lawful self-defense. I mean, often the possession wasn't transient. Often the felon's just carrying a gun around, in which case the defense doesn't really work because you're not privileged as a felon, ex-felon, to be in possession of a gun for speculative self-defense purposes. But you can be justified for being in otherwise prohibited possession of the gun for purposes, transient possession for purposes of immediate self-defense. And the last one I'll answer here, thoughts on a second mag when carrying concealed. That's from Matt. Well, there's no real legal issues there. I mean, again, I don't do gun law. So presuming that the magazine and stuff in the possession would be lawful under the gun laws in your state, right? I'm presuming that would be lawful. I don't claim to be any kind of gun expert. I've taken a ridiculous amount of gun self-defense courses. For many years, I taught at the Sig Sauer Academy up in New Hampshire, a fantastic facility, by the way. Of course, I was a subject matter expert on use of force law, as you might imagine. But because I was an instructor, an adjunct instructor there, I had access to all the courses they taught, including all their military law enforcement courses, which were fantastic. So I've had a lot of exposure to training. So I say that not to claim expertise. I don't claim expertise in gun stuff, but I've had that exposure. And of course, I carry a gun for personal protection. The prospects that you would actually need the ammo in a second mag that you would run through your initial mag and go to your second mag, statistically appears to be pretty unlikely. It doesn't happen very often. Of course, we have more of these mob type events, so I guess it could happen. But if you've shot that many people and they're still coming, I'm not sure a second mag is going to make the difference. But where a mag can be extremely helpful is if you need it not because you've burned through the ammo in your first mag, but because you had a malfunction in the gun. Some kind of malfunction, failure to feed, failure to eject, whatever the case might be. One of the most efficient default ways to clear a malfunction that's clearable is to simply dump the existing mag and cycle the slide aggressively a bunch of times and then put a new mag in and start over. So to my mind, the real tactical benefit of having the second mag isn't so much for the additional ammo per se, but it gives me the option to dump the first mag if there's a malfunction and go to the second mag and get the gun back up and running. And that, folks, was question 514 from this past weekend's Law Self-Defense Advanced class. So I'm done with those. And now I'm going to go to the Super Chat questions. Let's see. Emily told me she was sending me yesterday's Super Chat questions, and I don't see them. So how did you send them? All right. She's holding up her finger. Just a moment, folks. Okay. So I should be back. And while I'm digging that up, folks, I'll remind all of you again about our Rittenhouse bundle. Today's the last day it's available, folks, because today's the last day we're doing the follow-up Q&A for this past weekend's Law of Self-Defense class. You get our 4 best-selling courses, including the advanced class itself in digital form. That by itself is normally $200. By itself, that one class is $200. You get our 4 best-selling classes, normally $500 in total. You get them for just that $200. So you save $300. You won't get them as DVDs. The DVDs are just here as a picture to represent the courses. You'll get them as digital, streamed online courses, so they'll be immediately accessible to you. You don't need to wait for DVDs to show up. But today's the last day for this bundle. It's our Law of Self-Defense Advanced class, which we also call our core class, our Law of Self-Defense Defense of Property course, our Law of Self-Defense state-specific supplement for whichever state you want. There'll be a pull-down list of all 50 states. Just choose your state of preference. And finally, Law of Self-Defense Defense Against Riot, Looting, and Arson course, a dedicated course just on that issue. And here is my sheet of Super Chats. So let's start going through those. Well, okay. I'm hoping this will open. So there weren't too many from yesterday, so I'll do those first. Let's see. We know we need to be careful with 911 statements, but what about reporting the initial break-in? So presumably this is a forcible, unlawful entry into your home. You're calling 911. Should you tell them you're armed and will defend yourself? I probably wouldn't. I don't see any point, actually, to announcing that on 911. I would just tell them you're home, your home's being broken into, give them your address, your name, and tell them to get there as quickly as possible. They don't need to know you're armed. Now, once you hear police on scene, the police may come into the home, presumably announcing themselves as police. You wouldn't want to present yourself to police with a gun in your hand. That would be bad. That could get you shot. Even then, I'm not sure you would have to tell them you were armed. As you hear them coming closer, I would just make sure you put the gun down someplace so it's not in your hand. But I wouldn't feel any obligation to tell 911 that you're armed. The police are going to assume that everybody's armed until they determine otherwise. The police responding to the scene. Ryan asks, person A pulls a knife, takes a step towards person B. Person B puts a hand on his gun, and person A runs off. Should person B call the police? Well, you run into the problem there of the complainant and respondent. You would think that the aggressor with the knife, who ended up running away, would not call the police. They call the police all the time, folks. Now, they don't call the police and say they pulled a knife on someone and got a gun pointed at them. They just tell the police, hey, some lunatic pointed a gun at me. Here's what he looks like. Here's what his gun looks like. Here's the license plate from his car. And then the police show up at your house to arrest you for aggravated assault with a firearm. Because the police, there's an initial presumption that the person who calls the police, they're the complainant. There's a presumption that something wrong was done to them. That's why they're calling the police. And the person the police have to call or go to is the respondent. They're responding to the complaint. And there's an initial presumption that they're the person who did the wrong thing. Now, this is not a legal presumption that would follow all the way to trial, but it's long gone by then. But it can play a big role in guiding the police and how they investigate a claim of wrongful conduct. And they may well be conducting that investigation with that initial presumption that you're the bad actor. So certainly if it's a scenario where deadly force has been threatened, I would want to be the first person to call the police, or at least one of the people to call the police to kind of balance that initial presumption playing field. It's a bit less critical if we're talking about a mere display of something like pepper spray. A use of pepper spray, I would call the police. You're still potentially facing pretty serious criminal charges there. If it's alleged that it was an offensive and not a defensive use of pepper spray. But if you merely displayed pepper spray, whether then you should call the police is, I guess, more ambiguous to me. It would be a decision I would personally make in the moment. Arturo writes, I discovered your voice puts my 6-month-old to sleep. Okay, he thanks me. My wife asked if you ever considered reading children's stories. Well, of course I have. I have 4 children, so I've read a lot of children's stories. I never knew I had the power of inducing sleep, but that's good to know. Let's see. Sean asks, given the way jury trials have been going in Minnesota, would you recommend a bench trial? So a bench trial is where there is no jury. The judge acts both as the judge, the finder of law, and as the jury, the finder of fact. Normally, we split those roles between a judge and a jury. But in a bench trial, there is no jury. And then the judge is making all the findings of fact. So the judge is doing everything. The question is, given that if you fear that a jury might be sensitive or vulnerable to political manipulation or fear and feel obliged to come to a guilty verdict, would you be better off at a bench trial? Well, first of all, in a bench trial, you're presuming that the judge would not be vulnerable to political manipulation or fear, or might not be woke themselves. They might be. Judges come from lawyers. Lawyers come from law school. Law school is woke. You all saw, hopefully, Prosecutor Binger in the Kyle Rittenhouse case. If he stays in the law, and he probably will, he may well be a judge in 5 or 10 years, and then it's Judge Binger. Do you want Judge Binger being your judge in a bench trial? Now in an actual case, your lawyer would know the judge, of course, and would be able to provide some guidance on that. But it's also important to keep in mind that you don't always have the right to demand a bench trial. In most states, you can only have a bench trial if the prosecution agrees. Some states, you can demand a bench trial. So in Maryland, for example, you can demand a bench trial. The prosecution has nothing to say about it. But in most states, you would have to have the prosecutor's permission for a bench trial. Basically, the view there is that you have a right to a jury and the prosecution has a right to a jury. So either one of you can demand a jury, and a jury would have to be provided in that case in the trial. So it may not be up to you. In the Rittenhouse case, he did not have a right there to demand a bench trial. The prosecution would have had to agree. And if it is a politically motivated trial where these political factors are of concern, the prosecutor will never agree to a bench trial in those circumstances. They want the jury. They want the theater. Because mostly in these politically motivated prosecutions, there is very little or any legal merit. So if there's no legal merit, the cliche in the law is that if you're guilty, you want a jury trial, and if you're innocent, you want a bench trial. Because if you're guilty, your attorney wants the option to try to persuade at least one of those jurors that guilt has not been proven beyond a reasonable doubt. You can use rhetorical tricks, emotion, appeals to sympathy, and so forth. Those things don't really work with the judge because the judge is a legal technician, right? A legal expert. He's looking, in theory, at the black letter of the law. So if you're guilty, a judge is going to see that and just find you guilty if it's a bench trial. If you're innocent, your concern is that the prosecution will manipulate the jury through things like emotion and appeal to sympathy, as has happened in some of these cases. And in that case, you prefer to have a legal technician like the judge be the finder of fact in your case. So if what you had was a lawful self-defense case, but you're being politically prosecuted, you probably want a bench trial if you can get one, but you probably can't get one unless the prosecution agrees, and they probably won't agree. All right, so that was really all of them from yesterday. There were a few more super chats from yesterday, but I've answered them already elsewhere in these conversations. Let's see. What about marijuana and the Second Amendment? And I guess that one was asked today and yesterday. So that's really a gun law question, folks, and I don't really do gun law. I do use of force law. Marijuana or being drunk, intoxicated in any form in the use of force law context matters really only to the extent of whether or not your decision-making in use of force was reasonable. You don't lose your privilege of self-defense because you're drunk or you're high. You have the same privilege of self-defense as if you were not drunk or high. But if you make bad decisions because you're drunk or high, you own those bad decisions. There's no special self-defense for drunk or high people. It's the same standards as everybody else. Now, when it comes to gun law, weapons law, then yeah, being drunk or high can have lots of implications. Lots of states have their own weapons law prohibition about being in the possession of a gun, even in your home, if you're intoxicated. So that could play a role in a gun charge, but that wouldn't be a use of force law issue. Marijuana is particularly complicated because, of course, it's now legal in many states. It's very legal in my state of Colorado, but of course, it's still illegal on the federal level, and it is illegal in many states still. And that could have, again, gun law complications as well. I mean, when you fill out the form to buy a gun, they ask you if you're a habitual user of unlawful drugs, and marijuana is unlawful on the federal level, and it's a federal gun law form. So if you check that box, you know, the store probably won't sell you the gun, I would expect. Let's see, is from the 2020 riots, if someone angrily approaches you, yelling they'll hunt you down, kill you, burn your house, are you obligated to walk away, or can you take care of the threat on the spot? Well, you can't use force to defend against a speculative threat. That's what the element of imminence is about. Those 5 elements: innocence, imminence, proportionality, avoidance, and reasonableness. Get that infographic, folks. It's free, doesn't cost a penny. lawofselfdefense.com/elements gets you that 5 elements of self-defense infographic, or get our free book, which covers all this in detail. We do ask you to cover the cost of shipping and handling, but the book is free. Or you can order the book from Amazon and pay for the book and shipping and handling. It's up to you. But if you'd like to get the book free and just have to cover the shipping and handling, you can get our book, Law of Self-Defense, at lawofselfdefense.com/free book. We cover all this stuff in great detail there. You can't defend yourself against a speculative threat, a future threat. The element of imminence requires that the threat you're defending yourself against either is actually in progress, that's a no-brainer, or is imminently about to happen. Normally, we suggest people evaluate imminence, determine whether or not a threat is imminent by applying the AOJ triad, ability, opportunity, jeopardy triad. I talked about that over the preceding couple of days, again, covered in our book in detail, lawofselfdefense.com/free book, or in our bundle. Today's the last day for that bundle. I see I left it up this whole time. Sorry about that, folks. Lawofselfdefense.com/bundle. So if someone says, I'm going to find you later and kill you, no, you can't use force against them now to neutralize that speculative future threat. If they show up later and try to kill you, that would be the time to defend yourself with force, assuming, of course, the conditions have been met for the use of physical force in self-defense. But you can't use force today to prevent a threat that may never actually happen, because that's the view of the law. Lots of people threaten to get you later, but they almost never do. So the law does not privilege you to use force to neutralize a threat that is not yet imminent. Let's see. If someone throws hot coffee at my face, what force can I use? Can I assume that it's a precursor for an attack or robbery? maybe. I mean, it depends on the circumstances. So often people throw coffee at each other just because they're having an argument and someone loses their cool. If that's the only force that's reasonably threatened, well, then it's over. It's like if someone shoves you once and there's no follow-up, right? You can't use force for vengeance or retribution. That's not self-defense. Now, if there's reason to believe it's the first step of an ongoing attack, well, then you're defending yourself against that ongoing attack. You're not defending yourself against the coffee that's already in your face. All right, and I think that was, let's see. That might have been, I'm not sure if more super chats came in after that one. Let me, yes, one more. So here it is. Hope this is an okay question for the stream, but if you have a vested interest in talking to police, a family member is missing, you witnessed a crime, how would you go about making sure you do not incriminate yourself? Well, it can be difficult not to incriminate yourself. Obviously, so there's a video out there on the internet, something to the effect of never talk to the police. It's done by a law professor. It probably has several million views at this point. And he highlights a lot of the ways that people can get into create legal jeopardy for themselves in talking to the police. He suggests you never talk to the police. Frankly, I think there's a lot of merit to that video. I don't believe it really applies effectively in the self-defense context. I did my own video. Debunking is too strong a word probably, but debunking that never talk to the police video in the context of use of force events. I think there are circumstances in a use of force event where you will want to talk to the police. And obviously, if you're calling 911, you're talking to the police, right? Again, this is all stuff we talk about for almost an hour in our Law Self-Defense Advanced class that you can get in that bundle at lawselfdefense.com/bundle. We only have minutes left, really, for this offer to be good. I guess we'll leave it up for the rest of today, but today is the last day to do that. So you have to be very narrow when you're talking to law enforcement, particularly in the context of answering their questions. So if somebody's missing, there's obvious information you would want to provide, like what they look like, right? A photograph, things along those lines. When things become more open-ended, like, is there any reason you can imagine why this person might have fled, if they fled or ran away? I wouldn't get into an in-depth discussion about every argument you've ever had in your family, because heaven forbid that person shows up dead. What you told them might be used as evidence. Evidence is not proof. Evidence and proof are two different things, but might be used as evidence of a motive on your part to harm that person, right? You had an argument about this, that, or the other thing. So to me, the key is to be as narrowly focused as possible on the particular issue for which you want the police to be involved. And presumably it's time sensitive in some manner. If it's not time sensitive, if it's important enough to really engage with police over, you might consider doing that with an attorney. I mean, if you discover someone stole money from your business, for example, I would definitely talk to an attorney before I call the police over that. There's lots of complicated legal issues that can arise, including things like defamation concerns. You could make yourself vulnerable to civil suit. So if it's anything that looks at all complicated and time is not of the essence, you might consider retaining an attorney to have them mediate that conversation with law enforcement. Also, you're more likely to be taken seriously by law enforcement if you're represented by legal counsel in that sense. Okay, let's see. I think that is everything, folks. Okay. Emily wants me to address this. Why do I recommend CCW Safe over other similar organizations? So these are really legal service organizations. We all call them self-defense insurance programs. They're not insurance programs. They don't offer insurance. None of them really offer insurance. I'm talking about for personal use of force. There are companies that offer insurance for things like instructors, self-defense instructors, for example. That's not what I'm talking about. I'm talking about if you're involved in the use of force event, you're facing legal jeopardy, and these organizations would provide or pay for the cost of those legal services and perhaps other benefits as well. Why do I preferentially recommend CCW Safe as somebody to seriously consider if you're interested in this kind of coverage. And maybe you don't need this kind of coverage. Maybe you think your risk is low. Maybe you're sufficiently independently wealthy that $1 million legal defense is something you could self-finance. But if you're not in one of those buckets, if coming up with several $100,000 for a legal defense would require you to sell your home or your business or cash out your kids' college fund, or you just wouldn't have the money at all, then you might want to consider a financial partner who can provide those resources you need for that legal battle, because it's a lot like going to war, folks. And we'd all like to think we live in a world where the resources you can bring to the legal fight don't influence the kind of justice you get. But we do live in a world like that. And what resources you can bring to the legal fight absolutely helps determine the legal outcome in your case, the kind of justice that you get in your case. The more resources, generally speaking, the better off you are. The difference between a $400,000 legal defense and a $40,000 legal defense are night and day. In this Kim Potter trial, we just saw the defense brought on board an expert on slip and catch errors, how easy it is for people to make honest mistakes. I thought it was very good. Potter got convicted anyway, largely, I think, because the jury was misinstructed on what the law required for a conviction. But that expert was really good. He was very, very good. He really strengthened that defense. And he cost $30,000 by himself. So having adequate resources for the kind of defense you want, for the expert witnesses you want, your own expert to forensically examine evidence, for example. The state effectively gets all these experts for free. You have to pay for them. So having those resources and getting people like me, right? Having those resources is really, really important to your defense. Now, why CCW Safe in particular? A number of reasons. One is, I already mentioned, they have Don West, Attorney Don West, as their national trial counsel. And I think the world of Don West. I think he's in the very top ranks of criminal defense attorneys in the country. So having him on your team is a huge boon. Also, CCW Safe has I forget the phrase they use, but it's effectively an emergency response team. If you're involved in an event, they immediately fly out a team of people, including experienced homicide detectives, to go over the evidence in your case, talk with the investigators. They bring Don West, of course, and you have that team on the ground with you within hours of the event. And what happens in the immediate aftermath of the event can be critical to how the prosecutor makes decisions moving forward. For one thing, he sees you have a lot of resources behind you, and believe me, that influences whether or not a prosecutor is likely to charge and drag you to trial in the first place. Prosecutors like easy wins. If you look well-resourced, you don't look like an easy win. You look like a lot of work. And generally speaking, all other factors being the same, the prosecutor would prefer to take one of the other 500 cases on his desk that is an easy win, rather than lose a trial in your case. So there's that benefit. Also, CCW Safe doesn't have any limitation on the amount of coverage they'll provide. So whatever your trial costs, they'll cover it. A lot of these other programs have a cap. 100,000, 200,000, 300,000. Sometimes it's an unstated cap, but there's a cap. CCW Safe has no cap. In fact, they have no cap even if you're convicted. So a lot of these other programs, the moment you're found guilty at trial, their coverage of you is done. It's over. They've met their obligation and you are cut loose. But what if you're appealing that conviction? What if it's a case like Kim Potter, where obviously the law was misstated to the jury? Of course, you're going to appeal. Well, appeals cost a lot of money too. Well, some of these other programs, they just don't cover that. You're out of luck. Or they only cover you up to your whatever their cap is, and you've already met the cap, because the caps are always too low. You've already met the cap at trial, so there's nothing left under the cap to cover an appeal. CCW Safe will cover your appeal, and an appeal of that appeal, if necessary. What if you have a mistrial, and you're going to be tried again by the prosecutor? Well, CCW Safe will cover that second trial too. Again, if there's a cap in the competitor plan, you've hit that cap in the first trial. They may say they'll cover you for a retrial. What they mean is they'll cover you within the cap. If you've already hit the cap, there is no coverage left on the retrial. CCW Safe will cover you again for that retrial. And there are criminal defendants who have multiple trials 1, 2, 3, 4. Of course, there was a mistrial, or there was a reversal and a new trial, a reversal of a conviction by the appellate courts. So, I mean, just imagine you're convicted wrongfully at trial. You have to appeal that conviction. That's effectively a second trial, and you win on appeal. But all that does is reverse your conviction and award you yet another trial. Now it's 3 trials. You can imagine the expense and resources required. CCW Safe covers all of that. That's another reason why they're my preferred partner. That's why I'm a member with them. And I have to say that I've done a lot of partnering activities with them. I spent a lot of time hanging out with those guys at ranges, at events, at their headquarters. I'm not an employee. I don't work for them in any technical sense, but I spent a lot of time with them. And my perception of them is that they are a solid, honorable group of people who will meet their obligations to their members. And there are competitors out there, some big ones, who I can't say that about based on my actual knowledge of their decision-making on behalf of their members. So again, for all those reasons, I'm probably more. If I thought about it more, CCW Safe is my go-to. I'm a member. My wife, Emily, sitting just a few feet away from me right now, is also covered by CCW Safe. And I would certainly urge you, if you're thinking about these kinds of plans, to at least give them strong consideration. They may not be the right fit for you. Only you can make that decision. But they should certainly be strongly considered. And again, you can do that at lawofselfdefense.com/CCW Safe. And if you do decide to become a member, you can get 10% off your membership with them at that URL, lawofselfdefense.com/CCW Safe. Using the discount code LOSD10. That's LOSD for Law of Self-Defense, and the number 10. Okay, and another super chat. Would you recommend getting a concealed carry license in a constitutional carry state? So constitutional carry state is a state that says, as every state should, I should be required under the Second Amendment to the U.S. Constitution that if you're a law-abiding, mentally sound American citizen, you do not require a license from the government to carry a gun for personal protection, for lawful purposes. That should be the law everywhere, and every government law or regulation that infringes that right should be facially unconstitutional under the Second Amendment. That's my personal opinion. That's my professional legal opinion. Having said that, I assure you, if you violate a jurisdiction's gun laws, they will arrest, prosecute, and convict you if they can. So those laws are real, have real effect, even if I believe they are facially unconstitutional. So in a constitutional carry state, you don't need a license. Should you still get a license? I would recommend it. For one thing, there may be reciprocity with other states that recognize that license, but don't recognize the constitutional carry status of that other state. It doesn't carry over with you to the new state, but the new state may well have reciprocity for an actual issued concealed carry permit from that other state. And, they're generally not in most states. I mean, I'm not talking about states like New Jersey or New York or Maryland, but in states that are not viciously anti-gun, it's generally not that hard or complicated to get a concealed carry permit if you're a law-abiding, mentally sound American citizen. You'll get a course. I mean, anytime you have a gun, you want to make sure you're at least safe with the gun. Most of the legal stuff the courses teach are, and at least in the use of force law context, not great, unfortunately, but you have me for that. So I would generally encourage getting the actual concealed carry license if you have the means to do so. All right, folks, another 2 hours and 15 minutes of listening to me talk. Hopefully I've put all your children to sleep, if that was your goal in signing on to the live stream. We will continue to do live streams as I can continue to think of things to talk about, and as you continue to be interested in participating in them, so that they're mutually beneficial for everybody involved. This is, however, the last day for this Q&A follow-up. So the next live stream will be different in some respects. We'll see how it comes up. So because this is the last day of the Q&A follow-up from last Saturday's advanced class, it's also the last day for the Rittenhouse bundle. Our 4 most popular classes, normally $500 collectively, only $200 today, folks. Today is the last day. You can take advantage of that at lawofselfdefense.com/bundle. And with that done, I will just remind all of you that if you carry a gun so that you're hard to kill, that's certainly why I carry a gun. So I'm hard to kill. My family is hard to kill. Then you also owe it to yourself and your family to make sure you know the law so that you're hard to convict. All right, folks, until next time, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe.